Oh, okay. Yeah. Yeah, we can, if you wanna, chat after this and we can get something on the schedule and we can, yeah, let's do that. Yeah. Let's touch base after this, okay? Grab, hopefully not.
Oh, yeah. Oh, this one? Okay. Can you guys hear me okay? Is that working back there? We're going to go ahead and get started. Thanks, everybody, for coming out tonight. My name is David Zook. I'm the Cache County Executive. And this is the first of what will hopefully be an ongoing series of training opportunities for all of you. And I wanted to actually start first off and just do some introductions so we can find out who came out today. Paul, do you mind starting? Just name and role? Smithfield what? Planning and zoning, okay.
Brady Christensen with the Cache County Planning and Zoning. Doug Colassa at the River Heights City Council. Jason Watterson, I'm with the Cache Planning Commission, and I also work for Utah Government's Trust. So these as well.
Yeah.
And I'm Jordan Cullimore with the Ombudsman Office. Martin Lindsay with Food Planning.
Thank you. That's great. We have a really good cross-section across the valley and elected officials, planning commissioners, some staff. Thank you all again for coming out tonight. As I mentioned, this is something that we'd like to continue throughout the year and ongoing because we understand that land use can be a complicated topic. It's probably one of the more contentious things that we'll deal with in public service, and it's something that is constantly changing as well. The laws seem to change every year for some reason. Our legislature likes to mix things up a little bit. And this is also something that, as Jason knows, working for our insurance organization can sometimes get us in trouble and cause some legal issues for us if we're not doing things right. So those are some of the reasons why our countywide planning office is hosting these. And I want to thank them, Lauren, our countywide planner, and Chris, our department head, for coordinating this and putting it together. I won't talk too much more. I'm going to turn some time over to Lauren, but just, I guess, a couple housekeeping. Our restrooms are just right out here to my left and then to the right. And if you need anything, let us know. Thanks. Lauren?
Thanks everyone for coming out tonight. I've had a chance to meet a few of you, but just want to introduce myself. I'm the Cache Countywide Planner, so part of my role is to host trainings like these and go around to the various communities, and it's also great to get everyone in the same room. We're so spread out in Cache Valley, so it's great to get everyone together since we're kind of spread apart and don't talk a lot, but it's good to get everyone in the same room. So Jordan is here from the Property Rights Office, and I'll let him go over more, but basically it's going to be kind of an open training. We can talk about what people are interested in most, and yeah, so Jordan, if you want to.
All right, so I guess I can talk into the microphone, right? I don't usually have one of these. I kind of feel like a wedding something. Wedding singer, that's the one. Thank you. So yeah, my name is Jordan Cullimore. I am the lead attorney in the Office of the Property Rights Ombudsman. I find it helpful in these trainings. I've probably talked with a few of you. Hopefully you know what our office is, but a lot of people, because of the turnover, right, with councils and planning commissions, which is a normal part and feature of the job. Because of that, though, it's good for us to kind of introduce ourselves regularly and just let you know what we do primarily, because the legislature has established our office as a resource to you guys and also to property owners. So primarily our office, we're a, maybe I'll put up my contact information. I have 2 slides, this one and that one. So that's my name, our office, and then a phone number and an email address. And we encourage you to write that down, have it available anytime you have a question, property rights related. Please give us a call if you want to talk about it. We don't charge. We're publicly funded, so we're not going to bill you when the conversation is over. We enjoy talking about this stuff. We think it's interesting. We know people are passionate about it. Like the gentleman up here in the front said, land use and water. That about covers the contentious issues, right? When you're talking about city stuff. There's others, but those are the real fancy ones, right?
I come from St. George, where they actually shoot it out on the Arizona Strip for water.
My mom grew up in Oasis, which is down by Delta, Utah, and I've heard some stories. Let's just say that from my grandparents. So it's good stuff, right? Not something that you want to cross people over for sure. But that's why it's that much more important, right, to know what the rules are and to make sure we're following them in every case. So again, the legislature created our office to get involved. We don't represent anyone. We don't represent the government. We don't represent local towns or counties or cities. We don't represent property owners. We're a neutral, nonpartisan state agency. So our primary role that we play is the role of mediator. So we step in and try to advocate for fairness and balance in most cases when disputes arise. And we do it in primarily 2 areas, and both kind of are encompassed by takings, right, or property rights issues. So eminent domain, when the government needs someone's property, right, for a public purpose, then we can get involved and help the property owner understand what their rights are. We help the government too. Sometimes the government entity calls up and says, hey, what do we need to do, right, in the process? What procedures do we need to follow? Who do we need to talk to? How do we need to do things? If the government proposes or offers value for the land that the property owner doesn't agree with, we can get the property owner an additional appraisal. We let the property owner choose the appraiser. We hire the appraiser, and then the government entity pays for that additional appraisal. So that's a procedure that the legislature has put in place so that the property owner doesn't have to incur additional cost to try to make sure they're getting fair market value for their property if the government needs it. And then we also will schedule meetings, hold mediations, explain to the parties as they ask and as they're interested what their rights and responsibilities and roles and duties are. So that's what we do on the eminent domain side. If any of your communities ever needs to do that, please give us a call. We're happy to talk you through what the best practices are, how to make sure you don't violate anyone's rights, and how to make sure that you provide a fair process. Interestingly, a lot of property owners we talk to recognize and understand the need for the project, right, that's taking their property. There's a lot that don't too, right? There's a lot that just don't want it to even happen, and that's an understandable perspective as well. But there's a whole spectrum of perspectives, right? And we're here to try to help the parties understand rights and responsibilities and duties. So hopefully we can come out at the back end of it with the least damage, right? The other primary area we work in and try to be helpful in is land use, what we're here for tonight, right? And the primary dispute resolution tool we have in the land use arena is the advisory opinion, right? So if a developer or a property owner or even the local government, right, as for advisory opinions, we get requests from cities and counties and towns, and we get requests from property owners and developers and otherwise as well. When a dispute arises over how the law should be interpreted, or if the government can ask for this, those types of questions in a development proposal, then they can come to our office and say, hey, can you give us a neutral take on what a court would say, if we were to go to court over this issue, right? And so we get submissions from both sides, we learn the facts, we learn their arguments, and then we can mediate in some cases if it's appropriate and the parties are interested, right? Then we can schedule a mediation and get together and see if we can work out a solution. But if the question is just a purely legal question about, hey, how should this law be interpreted, or is this legal, those types of things, then we can produce an advisory opinion that the parties can then use to help resolve their dispute. So that's another tool that we offer. We do these trainings. We go throughout the entire state. We provide trainings, education, try to help people understand the rules and how to make good decisions, legal decisions, so that, as David said, from a county's or a city's or a town's standpoint, you don't expose yourselves to liability, right? That you're making good decisions. So we do a lot of these types of trainings. And then frankly, we just spend a lot of time answering emails and on the phone with people, answering questions and trying to be helpful in that way. So that's a general overview of our office. And please reach out, give us a call if you want to talk about something at any time. So is there any questions or comments at this point? We like these to be discussions. We don't like them to be lectures. If any of you know Brent Bateman, he was he trained me, let's say, right? So I was hired by Brent several years ago, and he was the prior lead attorney in the Ombudsman's office. I will tell you now, he is a lot more entertaining than me. But I am way smarter than Brent. So but Brent's a good friend, and we are trying to carry on the tradition that in many ways he established of providing useful and helpful trainings to communities all over Utah. So we find that they're best and most excuse me, need some water. Most effective when they're conversations, right? I was just kidding. I wasn't asking for anyone to go get me water. It's fine. But I just realized that sounded like a... thank you. I should have taken a drink before I got up here. But yeah, we like them to be discussions, right? We don't like them to be lectures. We want to just talk about the issues that you guys are dealing with, experiencing. We don't necessarily need you to tell us exactly what's going on, right? We talk in hypotheticals around here. But we do recognize that land use is an inherently local issue, and you guys are dealing with your own sorry. Thank you, appreciate it. Maybe I'll take a quick one here. Thank you for that. Okay. So yeah, this is kind of a slide we put up at the beginning just to kind of identify some general topics that come up in these conversations. We've had a lot of these conversations, and these are a lot of the issues that we discuss with people related to land use in their communities. So please speak up, raise your hand, shout me down, whatever you need to do as we go through our conversation to talk about things. So does anyone have anything they want to talk about? Otherwise, you just get to hear me talk about really exciting legal stuff. Thank you for asking. That's a really good one. Very insightful question. And it really does, in a lot of ways, start the conversation of how to make a good legal land use decision, right? And really it ties directly with the first one, legislative and administrative decisions, right? So public clamor is the term that Utah courts have actually used to describe public input when it's bad, when you're not supposed to be listening to it, right? And so that's why they use that term. A lot of people don't like that term. But it's just kind of a term that people use when you shouldn't be listening to the public's opinion on something. And there are cases where you shouldn't be, right? Or you shouldn't consider what the public wants. And different people have different opinions about this, right? From a legal standpoint, though, when it's appropriate and even necessary, right, that you listen to the public, it's called public input, right? So talking about, first we got to talk about legislative and administrative decisions. Both as planning commissioners and city council members and even staff, right? You're going to be involved in making both legislative decisions and administrative decisions. When you're making a legislative decision, you're making the law, right? So back to civics class, right? You got separation of powers. There's legislative, there's executive, and there's judicial, right? This is kind of a variant of that, where you got legislative, making the law, administrative, you're just applying the law that exists to a specific request or application, right? So when you're making the law, when you're making new law, when you're acting as a legislator, that's what the city council people do, or the county commissioners do, right? Planning commissioners make recommendations on legislative issues. So you guys, the planning commissioners, are the experts that look at it and say, okay, you know, what should we recommend, right, to the city council, who's going to make the ultimate decision about what the law should say, right? Some examples are your general plan. When you're enacting or amending your general plan, that's a legislative decision, right? When you are amending the text of your ordinance to create a new zone, right, that someone can request, a new commercial zone, C4, or a new residential, right? Those are legislative decisions. When someone comes in and then says, hey, I'd like to change my zoning from agricultural to residential or agricultural to commercial, that's a legislative decision, right? You're making new law, right? You're saying the law that applies to this property is this zone, right? Those are all legislative decisions. Public input is good in those cases, right? In that you should listen, right? I mean, it's even built into the process that you have a public hearing at some point. State law requires that you do it at least with the planning commission, right? And then your local ordinance can decide if you also want to provide a public hearing at the council level, right? I think everyone would agree that it's important to listen to what the public has to say in those cases, right? You're right that most of the time, right, depending on the project, there's always going to be what are referred to in the industry as NIMBYs, not in my backyard, right? It's up to you to decide if that's a good opinion or a bad opinion, right? If what is being proposed really is good for that person's backyard, right? And you could call it a sacred trust, right? That you're making decisions that have real impacts on people's property rights. Zoning affects property rights. It's that simple, right? The law says that's okay to an extent, right? It's okay because we live in we need an ordered society, right? And so it makes sense that certain uses don't belong next to other uses and certain restrictions are appropriate, right? The courts look at things and say, okay, council members, you are accountable to the people. So we trust you to make decisions that don't go too far, right? The law in a lot of cases isn't going to tell you when you're going too far and how you're encroaching on people's property rights. So it's up to you to decide where that line should be drawn, right? That's your responsibility as elected and appointed officials to say, okay, should we impose this restriction on houses in the, one that I can think of off the top of my head is that some would argue is maybe overly burdensome and others argue is appropriate. It really just depends on the community. Second kitchens. Should a house be allowed to have a second kitchen? That impacts property rights. There's no law that says it's one way or the other, right? So you got to decide in your communities, is that an appropriate restriction and where?
I think it's important to also consider the fact that not only are you, as a council person or it's a larger decision in terms of, it's not just respecting the input, it's also determining to your best ability what is the best for the wider community for which have been elected to be responsible.
Perfect. Yep, great point. Thank you. Yeah, I often think about it in terms of three groups, right? And there's overlaps between the groups. It's like, you know, circles that overlap where you have the applicant's rights, right? You have individual neighbors' rights, exactly, right? And then, and you pretty much said it, right? And then you have the community's rights, the community as a whole, right? What are their rights in the situation, right? And you got to consider the interests and the rights of all three of those parties, which again are overlapping, right? They're not exclusive, but it's truly a balancing act sometimes, right? In a lot of ways, you're arguably not very checked on the decisions you make, right? Other than by the people who may or may not vote you in the next time. But that happens slowly, right? And so you got to be very careful, and it's valuable and important to consider public input. Sometimes you're going to listen, sometimes you're not, right? And there's a lot of different factors and forces that go into that. A really big issue at the legislature right now, right, is housing availability and affordability, right? And kind of the trend there, you know, one of the big voices in that arena is saying we need more density. And you know what, you know, density is a big word, right? The reality is density is good in some places and not in others. So it's important to get input, but also, you know, try to listen to the experts, right? And what they say, and then find the right balance in your communities, right?
So in that case, with density, we're talking about property rights. So if I have a piece of property that has a certain density,
Mm-hmm.
and I want to become more dense, I want to upzone that piece of property.
Yeah.
And I am the applicant, I come before the legislative body wanting to upzone that property. You get a lot of public clamor that says they don't want that density to happen. And as a legislative body, you say deny that applicant.
Uh-huh.
You haven't necessarily taken away any of their property rights because they have a right to the property as it currently exists.
Right.
So they're going to say you took away their property right, but in fact you left it alone, basically. You didn't just expand it. Is that correct? Or at least a viable viewpoint?
Yes, it is a very viable viewpoint, and in my experience, it's a matter of perspective, right? From a legal standpoint, you can say, I mean, the courts have said that at its basic level, an individual can do whatever they want with their property as long as it doesn't create a nuisance, essentially, right, for someone else. And then every layer of zoning you put on top of that is a restriction of those property rights. But a lot of it deals with expectations, right? So you're absolutely right that if I purchase a property that is A5, I knew what I was getting, right? And those are the rights that I purchased. In law school, we learn about, you know, you don't really buy property, you buy a bundle of sticks, right? The right to exclude, the right to lease, the right to put a single family home on it, right? You can break it out and say, okay, these are all the rights that are associated with this property. They're sticks, right? And you can break some sticks and share them with other people. You can give some sticks away. You keep some for yourself. The right to exclude is kind of the preeminent one, right? The right to tell people not to come on your property. And zoning kind of decides what kind of bundle is associated with that property at that time, right? And so, yeah, when a person buys a property, and the courts have talked about this, right? They have an expectation and a knowledge of what rights are associated with that property, and they paid a price that considered that, right? So, yeah, definitely, if you leave something alone, one perspective, and there's other perspectives out there, right, is that you haven't violated any property rights. You've just left them with the property rights they have. Now, rational and reasonable people might disagree with that, right? But it's definitely a rational perspective to have, for sure. Good questions. Any other comments or thoughts there? Jason?
Just a thought on public input. A decision made
And again, I mean, if you want to call me and ask me about specific situations, I'm happy to tell you my opinion, right? But it's just going to be an opinion. And there are other opinions, and there's also statistics and facts out there. And yeah, you're absolutely right. You need to consider the whole gamut of things. I mean, that is the essence of policy and policy making in politics, right? Is deciding who gets what, when, where, and how, because resources are scarce. And so you got to take everything available to you as the decision makers and make the right decision, or make the best decision that you can come up with.
But I also think it's important that you have to understand that you start with a general plan, you have future land use plans, you have tools that are given to you as a planning commissioner and as a city council person that have been passed and approved by the larger body, so to speak, that help you inform those decisions and help you have some sort of confidence that you're going in the right direction. So that if, in Paul's example, he's in a single-family neighborhood and he wants to build a 12-plex, that might not be part of the overall future land use plan for that particular area. And thereby, it gives the planning commission the ability to say, you know what, it really doesn't, this doesn't fit with our future plan for this area.
Perfect.
So you do have some level of, back.
Yep.
Something has your back, so to speak.
Great. Thank you. That's a great comment. And yes, I mean, the process is set up so that if you follow it, and if people participate when they're supposed to participate, which that often is the kicker, right? Is sometimes people don't participate when they're supposed to. They participate at a later time or an earlier time, and that's when the disputes arise, right? But the process is set up so that if everyone participates when they're supposed to, then exactly, yeah, you'll have a general plan that got public input and kind of said, okay, this is what we want our community to look like, right? So when a zoning request comes in, you can look to your general plan, you can look to community input, you can look to other experts and facts, and hopefully with all those great resources, you can make a decision that's going to be a good decision, right? But yes, so public input is valuable, and frankly, you have a responsibility to listen to the public on legislative decisions, right? Because you're making laws that affect and impact them.
One thing I know, at least on the county council, that we've struggled with a few times is the notification process. It seems like people
Yeah.
within certain proximity of the project will be notified, but oftentimes even then they're not notified, depending upon if they've got a non-updated address or such.
Yeah.
I don't know how you're ever gonna get over that, but
Yeah.
that does limit and restrict some of the feedback that would be best from the people closest to it. It's always sad to hear that they found out about it after it was passed, but again, I'm sure there's nothing that can be done to change that.
Yeah, I mean, it's tough, right? It is. And state law, it only requires a notice to people whose properties are directly impacted by a zone change, right? So, and then it leaves it up to local ordinance to decide that bubble, right? That you provide third-party notice to. And there's a lot of different opinions. Your planners probably have a lot of really good ideas about public input in that regard. I mean, I've seen, you have your town days, right? Putting up booths and saying, hey, we're doing a general plan update right next to the really popular booth, right? That's one way to try to get more input. But there's social media, right? And as you guys know, a lot of these ways can be two-edged swords, right? But you got to be you're the ones who need to decide what rules you want to put in place and what practices you want to use to involve the public at the right times, for sure. So.
New to the state of Utah and still learning all the state law. There's no requirement to post on the property?
Not in state law.
Okay.
But I'm guessing your local ordinance has something like that.
Yeah, Chris, does ours?
Oh, okay.
Yeah.
Okay.
Okay.
Yeah.
Thanks.
Right.
Okay.
Yeah, it requires like usually by newspaper, right? So that people can go, but a lot of the notice mechanisms are designed so that people have to go look for it.
Yeah, and newspaper isn't really, people aren't really necessarily.
It's a little antiquated. But there is also a public notice website, right? And there is a requirement that people post things there. But again, both of those require people to go and be interested, right? Most people aren't interested until they see dirt moving out in their backyard, right? Understandably so. People are busy, right? But the system and the process is set up so that it does put a little bit of responsibility on the people to know what's going on in their communities. And that's important to recognize and acknowledge, right? You can't get past that. So that's something to encourage as well, you know? Great comments.
So I'll ask this question, it's gonna wait a while. Could you talk a little bit about either developments within your community that are already within the boundary and or annexations? And that particular development might really have an impact on some infrastructure, such as water. You know, you might, because of this 100-unit development, now you're gonna have to drill a new well. Or you're gonna have to, you know, have a major expenditure of some sort of infrastructure that comes from that development. Could you actually say you're not going to allow the annexation and or we're not gonna allow the development because we don't want to or don't have the wherewithal to spend the infrastructure money?
Okay. So that's a really good kind of case study to lead into the difference between legislative and administrative, right? Yeah, thank you. It depends on where you're at in the process, right? It depends on where you're at in the process. So annexations, that falls into the bucket of legislative decisions. So yeah, you guys have a lot of discretion, and one thing you should be looking at in making your zoning and also deciding whether to annex, availability of utilities and resources, right, and services. If they're not available and you're at the legislative decision-making stage, take that into consideration, right? Whether it's an issue of how much density, or whether it's an issue of even allowing development in that area at that time. There's a term, adequate public facilities, right? And some states approach the idea a lot more aggressively than Utah, right? Utah doesn't really have anything specific about, you know, determining where there are and when there are adequate public facilities for development, but it's something to consider, right? Do you have enough water for that type of development? What's it going to take to get roads out there? Sewer? Is storm drainage going to be an issue? Electricity? All those things that give us the quality of life that we have, right? They need to be considered. And at the legislative stage, yeah, if you don't have them and you have studies saying that you don't, you want to take that into consideration about whether or not you're going to make the decision you're going to make.
So it is okay in case of an annexation to say no because we just don't have the infrastructure.
Now, with annexations, what I tell people is there's a lot of procedures involved with an annexation, right? There's a petition, and then you got to decide to accept the petition, and then you go through a process, right? There's boundary commissions. Make sure you're following whatever that process says to follow, right? But yeah, ultimately, if you look at it and say, you know what, this isn't in the public interest to say yes to, that's really ultimately the standard you need to be looking at and following and making your decision.
What about pieces of property that are within your
Again, if they don't have the zoning that already allows that, yes, it's okay to say. So that illustrates the difference, right? If you have already gone through the process and changed the zoning on a property, and so now that person is zoned to allow 100 units or something like that. When they come in with an application and they set it on the table and they say, okay, here's my application to subdivide, or here's my site plan to show the apartments, right? And they pay their fee, right, to have the review process started. that locks everything in. That locks in the zoning.
As it exists in your general plan.
In your zoning, yeah, well, in your land use ordinance. Yep. So yeah, zoning, general plan is one thing, and general plan designations, they tend to be more broad and general. Zoning is more specific, right? And the zoning is what gives people the actual rights, right? And so yeah, it locks in the zoning, right? And now we're talking about an administrative decision, right? So an administrative decision, subdivision applications, conditional use permits, site plans, anything where you're submitting an application that says, here's my proposal to be reviewed under the rules as they exist right now, right? In Utah, the minute they do that and pay the fee, then it locks in the rules. It vests, right? They have a vested right now. And if you haven't done the work up front to look at adequate utilities and things like that, then you might be in a pickle. Because, yeah, if they comply with all the rules, if they comply with all the development standards, if they can pay all the fees, and have the access they need under the rules, they are entitled to approval, okay? So that leads back to the question of public input, right? Is public input good, or should we listen to public input on administrative decisions? When a subdivision application comes in, should we have an ordinance that says you have to schedule that for a planning commission meeting and a public hearing? It depends on who you ask. Generally speaking, well, and it depends on the type of public input. If someone comes in and says, we don't want that in our community, you can't listen to that anymore, right? Because if the code allows it, they're entitled to it, right? But if someone comes in and says, specifically, probably the area where there's the most, well, I'll say it this way. In most administrative decisions, it's going to be counterproductive to ask for public input, because people are going to come in with the belief that what they say is going to matter as far as what they want and don't want, and then they're just going to think that you didn't listen to them at the end of the meeting, right? Is my experience. The one area where I think public input might be useful is with conditional use permits, right? And specifically in the context of, okay, we have the ability here because this is kind of a unique use to impose reasonable conditions to mitigate potentially detrimental impacts, right? You might want to get some public input from the people that surround that use to find out what some of the detrimental impacts might be, right? But just that, right? And it's important, I think, that you frame things properly when you have those meetings, right? That you say, hey, we can't decide whether or not we want this to go here, right? As long as we can impose reasonable conditions to mitigate detrimental impacts, they're entitled to this use, right? But we want to know what you think some maybe potentially detrimental impacts are, right? What are some sensitive issues in the community that people might need to know about to be able to make conditions about access or hours of operation or lighting or smells or different things like that, right? Depending on the specific use. And then you can take that information about those potentially detrimental impacts, and according to the standards in your ordinance, you can craft reasonable conditions, right? To mitigate those impacts. That's not required. It's not required that you get public input, right? You can gain that information in other ways, but that is one potentially reasonable use of public input in an administrative context.
So I'm going to disagree with you.
Please
Because
do.
I think that
There's a lot of people that do, right?
there's lots of people disagree with me. But I believe that listening to the public in all situations is important. Mostly they understand that they can't change the fundamental decision, but they can have tremendous amount of impact on those conditions for that approval. And they can also have a tremendous impact on, quite frankly, sometimes reading the code better than you do.
Sure. Yeah, that's a good point too.
And they can bring things to you and say, but your code says this. How are they doing that
Mm-hmm.
in this particular project?
Right.
And I find that to be incredibly valuable because they're heard,
Mm-hmm.
they're responded to, and everybody, I mean, I think that every time you participate, you learn something.
Mm-hmm.
And once you learn that, then you can add to that and add to that. And that's part of being an engaged public person.
Perfect. And that, again, I'll pay you later too, right? But that leads to the second point, right? Is that when you're making a administrative decision, you have to decide, number one, are we following the law? And number two, where we have discretion under standards to make decisions, are we supporting our decision with evidence? The standard is substantial evidence, some good evidence, right? So yeah, if the public can provide input that helps you to understand how the law should be interpreted, great, listen to that, right? Or if they can provide input that gives you evidence to base your factual determinations on or your discretionary decisions on, you can consider that, right? Because ultimately, that's the difference, right? Is with a legislative decision, really you can take into consideration any information and you're just there to try to make good policy, right? With an administrative decision, you're there to make sure that you're following the plain meaning of the law and that you're providing your factual determinations and any discretionary decisions with substantial evidence. And you're right, any source that you can turn to gather that information is a valid source, for sure. So yeah, I mean, the ones I've seen where it's gone really well is you'll have an agenda. I'll walk into the meeting, I'll pick up an agenda, and I'll see what's on the agenda. It'll often be separated into, okay, we're going to consider legislative matters here, right? And then you can put on your legislative hat and say, okay, we're making policy. And then you have your list of items that are administrative, right? And then you switch gears and you say, okay, now we're applying the rules to this application, and it's what we can consider, and the decision we make has to be based on kind of more narrower circumstances, right? And then on the back of it, there may even be an explanation, right? Explaining, okay, in legislative decisions, these are the factors that we're looking at, and these are the things we're deciding. In administrative decisions, here's the rules that apply, right? And this is the type of input we're looking for, right? So if you have anything, please share it with us, right? That, in my experience, that helps to focus and also to just keep expectations realistic, right? Because in my experience, that's really where the problems arise, is when expectations don't meet reality for all of us, right? Yeah, great comments, great ideas.
I'll ask the devil's advocate question. So, administrative decisions. Can you deny, can you say no to an administrative decision? Conditional use permit.
Mm-hmm.
What would be the conditions under which you would be able to say, no, I'm going to deny this request?
Yeah, great question. So if what they're proposing is illegal or not in accordance with the plain meaning of the law, you can deny it, right? Or request they modify and come back with a proposal that does comply. The easiest and simplest is someone brings in a proposal for a home, and your ordinance says this, dwellings cannot exceed 35 feet in height. If they're proposing a 45-foot tall building, you can deny that, right? Until they modify it and bring it back. So that's the illegal part, right? It can't be an illegal proposal. It has to comply with the plain meaning of the law, right? In the context of like a conditional use permit, right, where there are standards that apply and you're looking at a use that maybe has potentially detrimental impacts. There's only been one case to date where a court has said the denial of a conditional use permit was appropriate, right? Okay, maybe that, does everyone know all the rules about conditional use permits? Yeah? So conditional use permits are kind of interesting. You got to be careful with them, right? And I think it would be helpful to kind of explain that to help kind of color the conversation. But you got permitted uses, right? Single family dwelling, yep, that's permitted, right? And then you got not permitted uses. So most ordinances will say if it's not listed, it's otherwise prohibited, right? So if I'm in a single family zone and the list of uses says basically single family and all the accessory stuff related to that, and I come bring in an application for a 2-family dwelling, it doesn't comply, right, with the plain meaning. But then there's this other category of conditionally permitted uses. Kind of the quintessential one is churches. A church is usually listed as a conditionally permitted use because in a residential zone, right? Because it's like, hey, this is beneficial in residential zones, but it's got some features and characteristics that really aren't normal for residential uses, right? Maybe higher traffic, larger gatherings, things like that, right? And so with a conditional use permit, you can say, okay, this is allowed, but we recognize there are potentially detrimental impacts and that it might not be appropriate everywhere, right? And so with a conditional use permit, you can say, okay, here are some standards, right, that need to be met, right? It needs to have appropriate access. It needs to not have these, harsh lighting or something like that, right? Parking, hours of operation, things like that. Another one is like maybe pig farms in residential areas, right? That might be conditionally permitted use if you're really brave. So there might be smells, right? You can look at proposals and say, okay, we can look at what's around it, and we can look at those standards, right, that says, hey, you need to consider all these things before you approve this use. And if there's a standard that applies to a potential detrimental impact of that use, then you can impose conditions, right, that mitigate. So that's the language, that mitigate those detrimental impacts. And if you can find, or the developer can propose reasonable conditions that that reasonably mitigate those detrimental impacts, then you can add additional rules, basically, right, to that specific use. And if you can do that, or if the developer can propose that, then it's still entitled to approval. But if you can't impose reasonable conditions that reasonably mitigate those detrimental impacts, in that narrow circumstance, you can deny a conditional use permit, right? And frankly, we don't have a lot of guidance from the courts about when you cross that line, to be honest.
I have a question about conditional use permits, but looking at it from kind of a retrospective approach.
And I know you guys are all thinking of the conditional use permit you have on the agenda tomorrow night right now, right?
I'm thinking in the context of trails, oftentimes communities are very enthusiastic and will go build illegal trails, and they mean no harm. Anyways, it has externalities on traffic and you name it, when it becomes popular or whatever. So it's this interesting catch because it's such a community benefit for some, and then there's still these externalities. But in some cases, is it possible then to go retrospectively through the conditional use permit process after said thing is already done and constructed? And is that a way to find a good path forward for the broader community? And does the conditional use permit then require the community to follow through with the condition, even if it was something that was done prior to the permit actually going through the process?
The best way I can answer that is to say there's nothing in state law that doesn't allow you to do a post hoc approval, right? And so really it's up to your local ordinance. And in a lot of cases, we'd probably encourage it, right? That you do provide a process that yeah, if it otherwise would have complied and it looks like it does comply, I think for a lot of reasons it's really smart to allow those people to go through the process, right? There might be a question of whether or not it was done in good faith, and that might come into play in determining those kinds of things. But yeah, I think it's also smart that you put any sort of a procedure for how to do that into your local ordinance, right? Yeah.
You could do permits on something that's already constructed and already in use.
If it's, if
That's
they,
what she was talking about, right? Trailers that were already built?
Well, if they were built under a permit prior, right? But if they weren't built under a permit legally, then, in other words, they're illegal, right?
or didn't go through the proper approval process, right?
With the community that they're
What's that?
in? With the community that they are in?
Correct.
Change of use would also constitute.
Yeah, change of use, that might trigger the requirement to get a new permit and to comply with new rules, for sure. Yep.
So I think what we're talking about is,
And if I'm not understanding something, let me know, but yeah, sorry.
for example, Jeannie's example here, where something is in violation of code,
Yeah,
can post hoc be approved as a conditional? I think if they were found in violation.
Legally existing non-conforming use.
Right. Well, it may be an existing non-conforming use, but if the community is willing to go back and impose certain conditions, and if the property owner is willing to abide by those conditions, I don't think there's anything in state law anyway that would prohibit the community from, after the fact, approving that use.
and I'll, yeah.
A bad precedent in terms of,
Well, I'll qualify that to say, don't do it just in an ad hoc, yes, we're fine, no, we're not. It has to be in your ordinance, right? And so if you don't have the rules in your ordinance, you need to put them there through the, mandated process of getting public input and making new law, right? But yeah, if that's in place and you want to allow someone to come in and file a permit and comply with those rules after they've started doing whatever they're doing, they still need to comply with the rules, they're just doing it kind of backwards, right? There's nothing in state law that says they can't do that, right?
it depends, do you want to be the community that allows them to fix their mistake, or do you want to be the community that requires them to bulldoze and start over?
Technically, you can do both, right? Yep. Yep. Or either, I guess I should say. Yep.
It's fairly common in the county to come across uses, structures that are built without permit.
Yep.
And that brings up a lot of health safety issues, it brings up a lot of impact issues, we talk about conditional use permits. The county typically is elected to use a more gentle approach rather than the full enforcement arm approach, and says, hey, you're not supposed to have done this, let's talk to a solution. That usually points them back to the permitting process, rather than an enforcement process to fines and misdemeanor charges. But we prefer not to pursue that.
Yeah. Okay. Thanks. Good comment. And yeah, those issues as far as non-complying structures, a really big one in my mind is non-conforming lots that were split without going through the subdivision process. Those are crazy sometimes, right? The recorder signed it. And that's absolutely right. Nothing you said right there was wrong. It is a legal lot. The question is it eligible for future development, right? Or is it eligible for a permit? And what the law says is that cities and counties can make sure that a lot complies before they issue a permit on it. And that is one of those areas where we actually have an advisory opinion out there. And I know, I think Cache County might be one of the ones who does have a post-division approval process to say, okay, you divided without going through the process. If you can do X, Y, and Z, we'll quote unquote legalize it, right? But some communities don't, and then that person is just left with a lot they can't do anything with, right? And it really is, admittedly, up to your community to decide if you want to have those kinds of situations in your communities, or if you want to provide a process for them to dig themselves out, basically, right? And I have seen a lot of requirements in there that, they were doing something in good faith, or that they were a bona fide purchaser who didn't know about the situation, right? Most of those provisions are less sympathetic toward bad actors, right? But you can be sympathetic to them as well if you want to, right? So.
Maybe is outside of the purview of what the Office of the Ombudsman really does and is.
Never stops us from having an opinion.
But I'm just curious, with federally managed lands, typically you go through the NEPA, the National Environmental Policy Act process.
You're getting really big brain here right now. Sorry.
Sorry.
Go ahead.
Like anything that disturbs the surface of the any soil surface. So if
give me a call. So we're talking about on federal land or federally funded. Is that the issue?
Yeah, just federally managed land.
Okay. Whenever our office has tried to call the feds, they pat us on the head and they say, because we are a state office, right? So we admittedly only deal with state issues on state lands. NEPA is really its own animal, right? And I took environmental law and I remember talking about it in law school, and I've looked up things here and there, but that is its own animal with its own expertise and specialty. And if you want to dig into that, I definitely consult a NEPA expert, right? As far as state land is concerned, right? We can talk about things there. I mean, there's like the trail by public dedication statute that you guys are familiar with, where if the public uses a thoroughfare for 10 or more years, then it becomes a public right-of-way, right? Again, that's applicable on private lands, though, within state jurisdiction. When you get into federal land and RS 2477, have you heard of the Public Land Policy Coordinating Office? plpco.utah.gov. Try reaching out to them. They're actually not, they've been around for a while. The new governor just reorganized, according to if you look at his 100-day, what he's accomplished in his first 100 days, he reorganized and revitalized the PLPCO. So I'd reach out to them. They're the ones who kind of deal with the whole state-federal relationship. They might have some really good resources. Yeah.
Property owners' rights, right? They essentially buy this bundle of sticks, but this bundle of sticks comes with a value, depending on what's associated with that bundle of sticks, or even the future potential for that bundle of sticks.
Sure.
You also have surrounding property owners who own their bundle of sticks, and it has value, either inherent or emotional. Right?
You bet.
Do you have any examples for when legislative action is taken that value of property owners'
Potential, yep.
or, real or potential?
Okay, yeah.
And where do you cross that line?
Great question. And that's why I said kind of at the beginning, to be honest with you, that there's not a lot of blinders or boundaries or guidelines set on property rights is exactly in that realm, right? Because the courts have said to that question, right? So let's say I own property and the government comes along and imposes restrictions, zoning or otherwise, that reduce the value of my property, right? The courts have said, you can go Google Lucas taking, right? So if the government eliminates all economically viable use of that property, it's a regulatory taking. Absent that, eliminating all economically viable use, there's another case that the Supreme Court of the United States came out with, years ago, that laid out the Penn Central factors, right? And said, okay, if a regulation reduces the value of the property, and then it lists these 4 things that still to this day, even the experts, they don't know what it means. And the court didn't provide any guidance as to what it means, right? So you look at all these different factors, and there's been litigation over it. The long story is that it's never really produced any satisfying results, right? So I think there's a case in Utah where a regulation reduced the value of the property by a significant amount. I think it was like 75%. It reduced the value 75%, and the court said it still has some economically viable use, no taking. And so somewhere between reduction to 0 and reduction by 1% is that zone where no one's come up with a good rule of thumb that applies in every case, right? And so what the courts have said is if you want to know whether or not there's been a regulatory taking, you got to come file a lawsuit and ask us.
So what are some of the judgments?
In Utah, that's really the only one I can think of. There's one out there that said, 75% reduction isn't a taking. I'd have to go make a list, to be honest with you, to find others. But there's somewhere, I'd have to go. We have an intern coming on May 10th. I'll have them write but I mean, it's enough that all we've ever really told people, right, is that if they haven't removed all economically viable use of your property, it's going to be an uphill battle to prove a taking. That's kind of the line that we tell people. Exactly, right. I haven't seen it happen in Utah.
The other option is they say, well, we'll go to the city where they'll let us do,
Exactly, yeah. So there's other ways to approach the question, right? But I think that's why, developers realize to argue a regulatory taking probably isn't going to be worthwhile or profitable, right? And I think that's part of the reason we don't have a lot of case law on it, So, I mean, if you want to be a case study, the Pacific Legal Foundation might be really interested. There's entities out there, right, who pick and choose throughout the nation states in which to kind of approach some of these issues, right? Regulatory takings, again, the rules are just so hard to understand, and none of the courts have really found a good way to approach them, that it's either, the zoning is fine and it's recognized that it inherently reduces the value of property. That's the one side of things, and unless you take all economically viable use. And so there is a case out there that says it becomes a regulatory taking when you go too far, but no one has said when you go too far. And so that's why I say you as elected officials need to figure out where it's appropriate to draw those lines so that you don't go too far, right? And looking to LUDMA should be helpful. LUDMA is the Land Use Development and Management Act, state law, right? But beyond that, it's really what you guys think is going to be right for your communities in a lot of ways, right?
Just to clarify if I'm understanding this situation.
Yeah.
Down zoning. So let's say we had a certain density and we made a decision, hey, we want to go to a lot less dense zone. Would that be an example of?
Yeah, so that's one of the factors in Penn Central is look at investment-backed expectations, right? So theoretically, if someone purchased a property that was a certain zoning and they had some really significant conversations with the community and the community had represented to them that, this is the zoning and you can do that here, and then they go start spending a lot of money pursuing that, but before they submit an application, the zoning is pulled out from underneath them, then one of the factors to look at is, were there quote-unquote investment-backed expectations? So that is one of those areas where theoretically, if you have that really specific scenario and you took it to court, you might get some recovery for a regulatory taking. Great questions. Oh, wow, 7-Eleven. When do we go to? Oh, okay. Any more questions? I'm happy to come back later if we're all tired. I know that this is incredibly exciting and engaging stuff, guys.
Tell us some cases that you've dealt with. So there's something that we can apply that you would put on the top of your list as errors that different communities have made or things that we need to
Okay.
be aware of.
Impact fees is a really big issue right now. Impact fees is a really big issue right now. Be careful with those. Try to make sure they're accurate if you impose impact fees. Go get an expert to follow the Impact Fee Act and make sure that you're only requiring property owners to pay their fair share of system improvements. That's one thing I think is really important. And admittedly, that's one thing that developers have a really sharp eye on right now, right? Which means that if you're imposing an impact fee that maybe isn't proportionate or correct, or only requiring the developer to set off their own impact, it might get challenged and might cause a lot of troubles, right?
Can that be under the name or the guise of an impact fee or not? Such as road requirements?
So now you're talking about exactions, which is also a really big issue, right? So an exaction is when you require a developer to build and then dedicate a public improvement. And you can do that to the extent that it requires them to offset their own impacts. So the one that everyone agrees on is internal roads to a 50-lot subdivision. You can require the developer to build those roads and then dedicate them over in any of the other utilities, right? But if we're talking about a collector road that you guys need as part of your general plan, and it happens to border part of that development, but the development otherwise meets all the requirements, can you require them to build that and then dedicate it? Probably not. You're probably going to need to use impact fees that you're gathering from the larger community, right, to build those types of things. Is that kind of what you were asking, or did I miss it? Yeah. So impact fees and exactions, those are always really hot button items. And yeah, you want to make sure you're doing those right.
We allow them, we expect them to build 50% of that.
Okay.
If it's a larger street.
Uh-huh.
Build again if it borders their property. In addition to
So one thing to keep in mind is just because your ordinance says you can, doesn't always mean the Constitution allows you to, right? And what I mean by that is, yeah, in some cases, a 50% requirement might be appropriate, right? But if the developer pushes back and says, I don't need that and I think that's too much, what the law says is that you have to make an individualized determination of whether or not that is proportionate to the impact they're having on the community. And there's a lot of art to this, to be honest with you, right? And in most cases, you get to the right answer through negotiation with the developer if they do raise that issue. But I would keep in mind that just because your ordinance says you can doesn't always mean that you can. Keep that in mind. You know what I mean? Yeah.
So when you say proportionally impact on the community,
Yeah.
would a good rule of thumb when you're looking at that be, but for the development, there wouldn't be any community impact, so then you can allocate that wholly to the developer?
That's a great way to think about it. Yep. Yeah. The but-for test, definitely. Yeah, that's a good way to think about it. But the kind of a yardstick that we give people is, and again, this is a yardstick, right? So depending on the specific proposal, it might skew one way or the other, right? But if every development and property owner built the improvements that abut their property, then everything would be covered and everything would be proportional, right? So for each single family lot, if they built curb gutter and sidewalk and a half width of road and all the utilities associated with that out in front of their property, that's within the realm where I think everyone would agree you're proportional, right? And then you kind of hopefully can take that to individual proposals, because the big questions arise when we need them to install a sewer line that isn't just a local line, it's a trunk line that runs to the plant, right? That's going to be more of a system improvement, and you should likely be compensating the developer for whatever upsizing is needed to make it a trunk as opposed to just the local line, right? Or with the road situation, right? If you got a collector road that just happens to run through that development, maybe you have them pay for the portion that would have made it a local road, and then you compensate them for the upsizing of it to a collector, right? That's usually how those issues are worked out when you're talking about proportionality. Does that make sense?
Switch gears to short-term rentals.
Ooh, boy.
Specifically out in Paradise, 4 acre and a quarter lots, and somebody's proposing a KOA for people to come in for a couple of days and drive a motorhome trailer, that kind of thing. Does that change anything
So that kind of an issue that you just described. So it's a KOA.
It's just somebody's letting traders come in and stay a couple of nights on their property and leave it, so don't consider it a KOA.
Oh, okay. Well, so state law allows you to say in your local ordinance when we talk about a short-term rental, typically it's defined as 30 days or less, right? You're staying somewhere for 30 days or less. If it's 30 days or more, then it's a long-term rental. But
That's on somebody's personal property.
yeah, so state law here and there says a few things about how you can enforce on short-term rentals. As far as whether or not they're allowed, that's still largely left up to the local community. But what you need to do is just make sure that your ordinance is clear, right? And that if the developer reads it, he knows whether or not short-term rentals are allowed, right? If your ordinance just says single-family dwellings are allowed, and it doesn't have a time-limited component to it.
Let me switch gears a little bit. This
Okay.
is a resident doing it, not a developer.
Okay. Well, and I use the term developer to mean property owner, right?
Okay, property owner.
Yeah. So yeah, if the property owner, so if they own a single family home and your ordinance says that in that zone single family homes are allowed, and it doesn't set any conditions on leasing or how long of a term someone can live there for, then they can rent it to the person for 3 days, or they can rent it to the person for 2 years, right? So if you want to restrict that, you need to make sure it's in your ordinance. So that's another thing to keep in mind when you're interpreting your rules. There's a tie goes to the property owner principle in land use that says if you can read a provision and it can be interpreted two different ways, in other words, it's ambiguous or unclear or vague in some way, then you favor the property owner's desired outcome.
Is that the same answer if there's a dwelling on the lot currently?
Yeah.
A family living on the lot and then parking in the backyard, so that still applies?
So that,
It's not an empty lot.
yeah, so if you have a dwelling already there and they want to come in and establish another dwelling, that might be more simple.
Or a trailer for a week or two.
Or a trailer for a week or two, then yeah, there's a lot of different questions that you'd want to look to your local ordinance. And so in other words, state law isn't going to give any clear, specific guidance there. You're just looking to your local ordinance, and does it say that accessory use to the primary dwelling, is that allowed, right? As far as like a second dwelling unit, for whatever period of time. Does that make sense?
Just on that kind of same topic, the legislature had an auxiliary dwelling
Yeah.
provision. That might be something that would be beneficial.
So that one, yeah, that applies statewide and says the problem that there's always a story behind every bill, right? And I think what that legislator was hearing was that people live in zones where they have a single family home and they want to establish an internal, so HB 84, I believe, it addresses internal accessory dwelling units. So local communities still have full purview over detached accessory dwelling units, buildings that are separate from the main unit, right? But if someone wants to come in and turn their basement into an accessory apartment, a lot of communities had rules in place that even though the zone allowed for accessory dwelling units, it functionally made it impossible, right? You had to have 4 extra parking spaces, and you had to fire separate everything, and you had to have separate meters and separate utilities and separate, HVAC and all that kind of thing. So what the intent, anyway, according to the sponsor of that bill, was to say, hey, when he first brought it up, he said, hey, internal accessory dwelling units are always permitted. You can't impose any additional requirements, local governments, right? Through the process, it was whittled back a little, right? So there are still certain areas of town, and it's new, right? And so that's why I'm kind of being a little vague here, is because communities are now trying to figure out how it works, because there's a lot of interesting provisions in there, right? But it basically sets limits on what type of rules cities, towns, and counties can place on internal accessory dwelling units. And if property owners can meet all of those conditions, then they're entitled to and allowed to do accessory dwelling units throughout the state now. So under those conditions. But those are, again, internal to the existing or main dwelling, right? Right, yep, owner occupancy is, and so that's a distinction between an accessory apartment and a duplex, right? Accessory apartments are in the context of single-family owner-occupied dwellings. If you have two families that are unrelated and neither one is the owner, that's a duplex under the, land use terminology, so. This is fun. Any other questions?
Yeah, well, and speaking of that, I came across something that as I was looking at some planning and zoning and rental, I haven't mentioned this to my city yet, but I just came across it.
Oh, excuse me.
And I saw this outside Las Vegas where they have, you can't rent out your place of residence, or at least when you're approved by it.
Hmm.
Summerlin.
Mm-hmm.
And
Was it under some sort of like a housing subsidy scenario, maybe?
so is that something that we can, as, let's say, duplexes come up or fourplexes, that we could put into our city ordinances without any state coming in and
I think so. And again, you bring up another reason why I say be careful, right? Because when enough stories reach legislators' ears, that's when they start restricting local control, right? And so that's a great question to ask, just from a very practical standpoint, right? Is, are we going to raise the eyebrows of anyone at the state level? There's nothing that prohibits you from doing it, especially if it's under some sort of a program to promote affordable housing. What I always encourage communities to do is find other communities who have done stuff like this and go ask them about pitfalls they've seen or problems they wish they knew about in advance. I know Provo City had a program where, they sold properties to people at below market value. They had, I can't remember where their funding came from, right? But it was some sort of program like that. It was some percentage of area median income, right? AMI is a big term you hear when you're talking about affordable housing, right? And one of the conditions of the sale was that they couldn't move for 7 years, right? Just to ensure that people weren't flipping properties, right? And making a profit off of it. So if you have some sort of a reasonable scheme that supports the public interest and pursues a public benefit, you're probably going to be fine, right? But I definitely look to other communities who have done things, and in doing so, they weren't challenged legally, just so that you could have some context, you know what I mean, about what kind of things might happen.
I think Sullivan is probably an HOA, so they might be able to have different rules than a community might be able to have.
HOAs can have different rules, yes. Yep.
They're a whole different animal.
Correct. An HOA, the way I describe that is it's a private contract between the property owner and the HOA. And so the rules governing again, as long as it's not violating some sort of a federal rule related to discrimination, that's really the only place where the government has gotten involved in HOA law, right? Outside of that, yeah, if you purchase a property that's subject to HOA rules, you're given a copy of the CC&Rs, you're given a copy of the bylaws, and you're going to be subject to those. And you're also going to be subject to any changes they make through the process that they've established for making changes. And so yes, HOAs operate as a micro city or town in a lot of ways, and in many cases are much more restrictive than zoning. Some cases they're not, but they could be, right?
Can I back to her question a little bit? Is there anything, regulations like that with neighborhood nonprofits as far as how long they have to live there?
I don't know. That's a great question. I don't have a good answer for you there. I would assume so, yeah. I would assume that if you're working with a housing nonprofit that number one, they're going to have probably some federal rules that are going to be applying, right? Because they're probably going to be getting funding from those kinds of sources. And then I would guess they would have some rules. I don't know what they are, though, to be honest with you. Well, eyes are looking a little droopy. Well, this has been great, and thank you guys for inviting me out. Happy to come back next year. We regularly come back annually just to have these conversations if you think it would be useful. And please give us a call if you want to talk about something that might be a little more sensitive or is very fact specific. Again, where we're a neutral party, we don't share anything with anyone that you don't want us to, right? We'll not that, yeah, usually the public process is public anyway, right? So it's not a big deal. But if you have questions about specific situations or anything like that, please give us a call. So.
Thanks, Jordan. Thanks everyone for spending your thanks for spending your Monday evening. I know Jordan said this may not be super interesting, but I find you said it yourself. But no, as a land use nerd myself, I found it really, so thank you so much. I really appreciate it. With that being said too, we did record the meeting tonight, so I will email it out to everyone. And so feel free to share it with people from your community who weren't able to make it tonight, because I think it's really important information as well. And if there's anything that really sparked your interest tonight to look into your own ordinances, part of my role as the countywide planner is to assist you with your ordinances and help you to rewrite, some of your code, give you more information. So please, if there's something that you're interested in, want more assistance with, please reach out to me, and happy to help you out. So thanks everyone.